because the UN was founded on the two-prong principles. One, international peace and security. Two, human rights and freedom. I find this in the US in the preamble. You find this in Article 1, sub 3, and Article 56, sub C of the UN chapter. By this time, Africa was not free. This, the UN Charter, another UN Charter, now this protective mechanism envisages African or Africans. Even though Africans took part in the Second World War, in the fight for freedom, the fight against impunity. Now, in 1948, the Universal Declaration of Human Rights was declared by the UN. Paradoxically, it was in 1948 that the war, I'll call them genocidal wars against Africa and Africans, commenced. In Cameroon, for example, the nationalist leaders who had founded the UPC were seriously repressed, with France from 1948 to about 1960 committing one of the first genocides on the African continent. More than 500,000 in parts of Cameroon, the paramilitary Bassa countries, were exterminated in cold blood. It remains a fundamental secret today. Nobody talks about that genocide. It's within this period that the war in Nigeria was perpetrated. It was within this period that the Portuguese wars in Mozambique, Guinea-Bissau, and part of Africa were exacerbated. But then, the Universal Declaration of Human Rights was never applicable. Nobody thought that because of the Universal Declaration of Human Rights and the provisions of the UN Charter that supported and protect the promotion and protection of human rights, that it would be applicable to these Africans. No, it wasn't, because Africans were never contemplated. Indeed, permit me to say, Africans were never considered as free people. They were never considered at the time as full human rights worthy of protection in international law. Now, a few months ago, most of Africa celebrated what they call the 50th anniversary of independence of African states. But if you look at this celebration of 50th anniversary of independence, on the background of international law, especially international humanitarian law, international criminal law, there are ad hoc tribunals that were set up in Africa after some African conflicts, and the ICC, and the enforcement and implementation of international law in general. You'll find that these international law instruments have acted more to enslave Africa. In fact, Africa has lost its independence since the notion of international law was applicable to African conflict. I will explain radically within the context of the paper of the subject matter that I will ask to write today. The International Criminal Tribunal for Rwanda, as the statutes of the court, Article 1 of the statute, and the UN Security Council resolution affirms, was created first to prosecute persons that they recognize had perpetrated crimes against humanity, genocide, and war crimes in the territory of Rwanda, and Rwandans in neighboring countries. A UN resolution of 2004, Security Council resolution 2004, reaffirmed that member states should cooperate in bringing Mr. Kabuga to trial together with members of the Rwandan Patriotic Front who perpetrated crimes in Rwanda and the territory of neighboring states against Rwandans. What we've seen today is that that Security Council resolution has been ignored with impunity, with no consequences. Prosecutor after prosecutor have been to the Security Council to present false reports. But as one of the penalists has stated before, because it was not convenient in the United States to prosecute the RPF, Paul Kagame and others who perpetrated crimes that led to the massacre of 6 million people in the Congo, because that is what the mandate is. The mandate extended to crimes perpetrated in neighboring states. That question was never asked. Indeed, the Security Council rather endorsed what we call selective justice. Selective justice, distinguished ladies and gentlemen, colleagues, is a violation of the UN Charter, Article 1, Sub 3, against discrimination, all forms of discrimination and prejudice on the basis of race, the basis of gender, on the basis of religion. Now, selective justice in the context of Rwanda violates the charter rights, UN charter rights, of the Hutu, who have been hunted down not only in Rwanda, but across the globe, in Canada, in the US, and together with what today is called the genocide ideology, even Hutus who are not yet born fall within the ambit of this law. Hutus who were not born in 1994 can be found guilty of genocide ideology. In other words, they could be brought within the remit of the alleged genocide that took place in Rwanda in 1994. This is discrimination. It violates the UN Charter. It violates the International Covenant on Civil and Political Rights. It violates the statutes of the court itself. It violates the US, the Security Council resolution of 2004. Now, if that was not all, in the context of Rwanda, as you were, the International Criminal Court has attempted through the back door to prolong the mandate of the ICTR by bringing selective indictment against Rwandans, purporting that they participated in the crimes in the Congo, the FDLR, and other Rwandans. So although the ICTR will be gone officially, the ICC will pursue this agenda, this criminal agenda, of selective justice against the Hutu. In other words, as I said in the previous conference, what we have at the ICTR, which is now being prolonged by ICC, is what we call the judicial genocide of the Hutus. It is humiliating for Africans, it's humiliating to Africa, it's humiliating to the black race. Now, let's talk a bit about the Special Court for Sierra Leone. I was lead counsel in the Special Court for Sierra Leone for the Revolutionary United Front for Sierra Leone, Major Maurice Kalon. Presently, I'm back to Sierra Leone as counsel for Mr. Samuel Kavo, one of the leaders of the West Side Boys. The case is ongoing, and I will be back there on the 8th of this month. Now, it may be argued that the Special Court for Sierra Leone is different from the selective justice we had in Rwanda because all the sides to the conflict were prosecuted. Oh, but that's a lie. Because the mercenaries that were brought in, the executive outcomes from South Africa, sideline from England, the crimes perpetrated by ECOMOG, the UNIMO from Liberia, and of course the armed forces of Sierra Leone, none of them was ever called to account.